To notable approvals. I am attorney Amanda Shaffer. Got some more exciting dismissals to talk about today. Before I get to that, quick reminder, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video to be helpful, if you can click that share button and get this over to some other people who might find it helpful as well. In addition, I sometimes forget to say this, that if you're on YouTube and Facebook, our contact information is scrolling across the bottom of your screen. On Instagram, you can head to our bio page and find it there. So today I have two more dismissals to talk about from immigration court. Before I get to that, a quick word of caution. So I was just talking to some of my clients, and we've been doing a lot of these motions to dismiss, motions to reopen, removal proceedings, and so that people can adjust their status or just not get deported or whatever the case may be. And this is a really great time to be filing motions like that. However, everybody wants to go ahead and get it filed, but you really want to make sure that you're not going to have any problems if you file. What I mean by that is that especially if you have an order of removal, there's a reason, right? I mean, it might have been you just lost your asylum case and that you just came with a visa and you overstayed, but it's not that easy to get a case reopened even now. Plus, if you appealed your decision, which if you tuned into our last notable approval, where I talked about our VAWA client, it took 4 years. I think it was 4 years since the BIA had it to make a decision. It takes a long time, and the BIA doesn't have to grant your motion to reopen, even if the government agrees. So what I do when every client who requests me to do it, I make sure I review their FOIA file or Freedom of Information Act file, which is their entire immigration history. If you don't have it, we can order it for you, or you can get it yourself from immigration. But we need to make sure that you're admissible or you're not inadmissible. So if your I-130 was approved because you married a U.S. citizen, that's great. But if you can't get a green card still because of some other issue, then they're not going to agree to it. So you're not only wasting your money, you're also telling the government, hi, I have an order of removal and I'm still in the country, which is, again, they're not targeting you, but in the future, that can change if the presidential administration changes. So that's just a word of caution. Of course, we're happy to review any case out there if you're looking to have your case reopened or dismissed or some type of prosecutorial discretion. We can certainly help you with that. So today we have technically 6 cases that were dismissed, although one was a family of 4. So this case, with this family of 4, they're natives and citizens of Indonesia. They entered the U.S. in October of 2016 with visitor visas. They did timely file for asylum, so within the year of entering the country, based on their persecution as Chinese Christians, which used to be a very common asylum claim from Indonesia because of what was going on in the country back then. Well, not back in 2016, it goes even further back in time. And that was the problems. Even when they came here, there was a change in country conditions. It had already gotten better. And, we were kind of, they wanted to file because that's what they wanted to do. And we told them, it's going to depend on, while your case is processing, what happens in your country. If things are going to get better for you or worse. And things, unfortunately, but fortunately, depending on how you look at it, did get better over there for them. So that made their asylum claim really hard. So we kind of went back and forth on, what we were going to do. And in 2021, this was actually my first time back in immigration court since the pandemic hit. We went to the judge, and he said, well, what do you guys want to do? Do you want to go forward? Do you want prosecutorial discretion? And, my clients didn't want their case dismissed because that meant they didn't have a work permit anymore. However, the problem was if we didn't ask for dismissal, they weren't going to do administrative closure, which is where your case is you're still in removal proceedings, but you don't have a future court date. And it's easy. Either side unilaterally can ask the court to put your case back on the calendar, as opposed to dismissal where you have no court proceedings, you're out of it. Any applications before the court is no longer in existence. So usually people have their work permit based on their asylum, and now they're not going to have that. So we went back and forth, and it's like, well, if you guys don't get your case dismissed, you're probably going to get an order of removal. But then the judge said, well, we're not just going to dismiss your case because you're nice people. There needs to be some sort of relief from removal available. So back in 2021, this is what we were just talking about. And it turned out the oldest daughter in the family, who then was a minor, now is 21, but she does get to stay on the parents' application since the case was started with her as a minor. She had been dating a U.S. citizen for years, and they were engaged. They just weren't rushing to get married because they were young. And we kind of said, well, I kind of said to them, I said to the judge, well, she's, engaged to a U.S. citizen. He goes, well, engaged isn't married. And he said, all right, this is what we'll do. Because I have my own ethical dilemmas with forcing people to get married. I didn't force them and didn't think I was, but I wanted to have my time with the clients to make sure that they really understood what they were doing and they were really okay with it. Because the ultimate plan would be that the daughter marries her boyfriend, fiance, whatever he was. He files a marriage petition, the case gets dismissed, she gets her green card, she 3 years later gets her citizenship, and then files for her parents, which you can file for your parents of a U.S. citizen. So we, the family took time to talk about it, and we had some meetings with them, and they then informed me not too long after we decided to get married. And I said, great. And if they had told me not, I would have said, okay, let's take a crack at the asylum case. We got to go forward, with something. So the judge said, get married, file the I-130, and then file again for prosecutorial discretion to dismiss. So when you file for prosecutorial discretion, you have to first contact the Department of Homeland Security and say, will you join us? If they say no, the judge is not going to dismiss your case or do whatever you're asking to be done. So we had to go through that motion twice with them. So they got married. He filed the I-130 for her, and that got approved back in November. And after we filed the I-130, I sent it to the judge. I sent it to DHS. They agreed. I sent it to the judge, and both the government attorney and I couldn't remember if we ever got the order that granted the motion, but we definitely knew we filed it, and the judge even said he was going to grant it if the conditions were met, which they were. But then the government attorney actually contacted me like a couple weeks ago and says, hey, this case is on the calendar for last week it was. Do you know why? Did you put it back on the calendar? I was like, no, we didn't put it back on the calendar because we all thought it was dismissed. And she's like, I don't know why it was put back on the calendar. I don't know if this was a mistake. But let's refile this motion. So I drafted a new motion for her. She signed it. I sent it into the judge. And then we get there, and the judge basically was like, I never got the motion. And I was like, I sent it, Your Honor. And he's like, I believe you. I don't know why I don't have it. He's like, I'm going to grant the motion, on request of the party, joint request of the parties. And then he was like, kind of was asking, the younger daughter, what she wanted to do with her life. It was a nice little, I guess, end to their case. And, some of the judges don't care at all. It's nice to see a judge care. But basically, the family is very happy. They got their dismissal. The work permit's nothing we can do about, but the daughter now can file for her green card and her work permit. And like I said, as long as she stays married to her U.S. citizen husband, she only needs the green card for 3 years to file for her family. The only person she won't be able to file for is the youngest daughter or her younger sister, but hopefully her younger sister will find her own U.S. citizen by then to marry. But if they had the order of removal instead, it would have been really difficult for us to reopen the case, which is what I was kind of talking about earlier. So congratulations to that family. We've known these clients for quite some time. It's always interesting for me because I'm not that old to see little kids when they first come in and now they're big kids or adults. That tends to happen a lot these days. Case number 2. A native and citizen of Senegal who also entered with a visitor visa. However, he entered in 2010. In 2012, he was detained by immigration. Now, 2012 was when I started practicing law, and I remember this client because he was already our client, and Aaron was doing everything. And he was in detention, and Aaron had to bond him out. Now, I'm pretty sure he was put into immigration detention after he was arrested. He had a few arrests. Nothing serious. They were all dismissed. But back then, and it can still happen now, but primarily back then, if you got arrested for a crime, even if your charges were dismissed or you were released on bail, you then got picked up by ICE and got put into removal proceedings. So that's what happened with him. So he filed for asylum in 2013. Clearly, that's not within the 1-year limit. So he got lucky, this guy. I don't know how strong his asylum claim was because, like I said, I wasn't the one handling this case at the time. What I do know is he got lucky because that was the Obama era where they were administratively closing cases. So now we're in the Biden era where they are dismissing cases, sometimes administratively closing. Why one or the other? That's the $100,000 question. The $1 million question is why your application is taking so long. That's the $1 million. Actually, that's the $1 billion. We'll say this is the $1 million. Why the government does what it does. But point is that what ended up happening was they decided to administratively close his case. And that was in 2015. And I remember Aaron had all the prep, like they had done the prep at least once for the individual hearing. He had all the evidence submitted. I mean, I believe he had a legitimate case, but you have to remember something also. Because A, he's filing outside the 1-year deadline, and B, he's filing a defensive asylum application. Defensive asylum application is filed after you're put into removal proceedings. So that means your burden of proof or how much you have to prove in order to get granted is even higher. So it's higher because you're outside the 1-year deadline, which also means you're not eligible for asylum unless there's some sort of changed country conditions, which was the argument. And on top of that, you now have a higher burden of proof because of a defensive asylum application. So the best, those are hard to win. So unless it's just really clear cut and you file within the 1 year, like we've gotten for people who were detained on entry into the U.S. and literally their first day of freedom in this country was after they won their immigration case, won asylum. But that wasn't the case here. So he had a really good deal. He got to keep his work permit. He had his case administratively closed in 2015. And I think this was the guy who went to Alaska and lived on a fishing boat, fished. I don't know where he lives right now. Or then I should say, I know where he lives now. But unfortunately, Trump came into power and things changed and they started reopening or recalendering is really the right term, recalendering cases. And that's what I was talking about earlier, that you can do unilaterally. So what DHS did was they sent us a motion to recalendar. We could have responded and objected, but it didn't matter because they are allowed to do it without our consent, or the judge can grant it without our consent. We could have done the same thing. Why would we ever file to recalendar a case that was closed? Well, if someone didn't have relief from removal but now does, that's a good reason, because they want to get lawful status. In this case, this client was, by this time, he had married a U.S. citizen, had 2 U.S. citizen children. So once his case was recalendared, what we did was, all right, well, what's his relief going to be? And his wife filed an I-130 marriage petition, and that was approved. And we then requested prosecutorial discretion so that he can dismiss his removal proceedings and file for his green card with USCIS. And the immigration judge granted that. The immigration judge actually granted it like hours before we were supposed to appear for the individual hearing, but we knew the government had already agreed. It was a matter of, do I have to appear on camera or not? Which is nice. In the past, I would have been sitting at the courtroom waiting. So this client's very happy, of course, and we're ready to move on to the next step, which is filing for his green card as well. And, these dismissals aren't coming as fast as we want in some cases, but they're coming. And like I said, I've had a number of clients where I've spent hours going through their file trying to decide if we were going to file it, and ultimately being like, look, this isn't going to get approved. We don't recommend it. And that's what you want. You want your lawyer to be honest with you and not just take your money and forward it. Because basically, if you file it, like I said, you're kind of putting up a flag saying, hey guys, I'm here, I got a removal order, or I'm here without immigration status. And that's obviously not ideal. So we're very happy for these clients that they can take the next step in their immigration journey. Although I said the family of 4 has a long way to go, but stay out of trouble. Just pay your taxes, do the right thing, and they should be able to get their green cards eventually, which is a pretty cool thing. And we're hoping this prosecutorial discretion continues. I have a few more to submit this week. I'm waiting on some more. Of course, I will update you. And if you're looking to have your case dismissed, reopened, reviewed, whatever the case may be, as I said, our contact information, YouTube, Facebook, scrolling across the bottom of your screen, Instagram, you can go to our bio page and find it there. If you found this video to be helpful or know someone who may, please hit that share button so we can get this information out there. And of course, don't forget to like us and follow us, Facebook, YouTube, Instagram, wherever you're watching, so that you don't miss any more of our lives. And that was all for now. So thank you all for watching and have a great day.